Namaskar everyone and welcome back to my channel Legalese by Aditi Sahai. From today onwards we will discuss some important case laws in the history of law. So moving on with the first, that is Ashwini Kumar Upadhyay versus Union of India. Did the Supreme Court miss an opportunity to bring equality in India's marriage laws? Let's talk about one of the most debated constitutional cases, that is Ashwini Kumar Upadhyay versus Union of India. The issue before the Supreme Court was simple on the surface but deeply significant. Why is the legal age of marriage in India is 18 years for women and 21 years for men? Shouldn't the law treat both genders equally? The petitioner Ashwani Kumar argued that having different marriage ages under, based on the gender is discriminatory and violates the constitutional guarantee of equality under Article 14. He also questioned why different personal laws continue to prescribe different standards and urged the court to establish a uniform gender neutral minimum age for the marriage. Now many expected the Supreme Court to settle this debate, but instead the court took the different approach. The bench headed by Chief Justice D.Y. Chandrachud observed that the real relief sought in the petition would effectively require the changing the law itself. The court emphasized an important constitutional principle, the separation of powers. It stated that making or amending laws is the responsibility of the parliament, not the judiciary. Courts can interpret the laws and test their constitutional validity, but they cannot step into the shoes of the legislature or rewrite the policy. As a result, the petition was dismissed, with the court making it clear that in India that if India wants a uniform age of marriage, it is the parliament who must enact such reform. This judgment raises some thought-provoking questions. On one hand, Supreme Court respected constitutional boundaries by refusing to legislate that from the bench. On the other hand, the critics argued that the judgment missed the opportunity to address gender inequality. If equality is a judgment fundamental right, should courts wait indefinitely for the legislative action? The decision also did not deeply examine whether the different marriage ages and specific religion specific marriage laws are compatible with modern values of equality and discrimination. So the case leaves us with the most important lesson: not every social reform can come from the courts. Whether you agree with the judgment or not, Ashwini Kumar Upadhyay in Union of India remains a landmark discussion on equality, judicial restraint, and the balance of powers under the constitution. What do you think? Should India have the uniform marriage age for both men and women? Let me know in your views in the comment section down. And please do subscribe and hit the bell icon so that you cannot miss any updates coming from my side. Thank you for giving so much love to my last videos, and bye everyone.